Hey everybody, welcome back to the channel today. We've got more updates on more lawsuits, how CRPA is participating in them. To talk about that today, we've brought on CRPA's volunteer president, Chuck Michelle. Chuck, thank you very much for being with us today.
Always a pleasure.
So, Chuck, I just wanted to kind of get a status update on a big thing that we've been talking about. That thing is Amicus briefs. But before we do that, please, you guys like, share, and subscribe to these videos. It really helps with the algorithms. We're trying to get this information to as many people as we can out there, and we're trying to help as many people as we can out there while we do it. So please like, share, and subscribe to the videos. It really helps. So, Chuck, I guess, can you just give us an overall update? We've talked in the past about amicus briefs, how they are important, how they can be used in lawsuits. If you can give us a general overview of that, but also any sort of update that we have on CRPA's campaign to affect lawsuits with amicus briefs.
Sure. Well, recall that, well, first of all, consider California has always been sort of the moldy petri dish for bad gun control laws. They have more gun control laws on the books than a lot of other states combined. But now, faced with the Bruin decision and some of the limitations on what state legislators can do, the Bloomberg folks and the anti-gun folks are pushing states to pass laws that are like California's laws. They're pushing other states to pass those. So semi-auto bans, magazine capacity limitations. We're going to be looking at micro-stamping in some of these states. I wouldn't be surprised if ammo restrictions come along. But what we've realized is that this is a national game. It's not just about California, and you're short-sighted if you just play ball in California. So what CRPA has been doing is, first we'll go out and we find the other cases where there are similar laws. Like we just did a brief in Delaware on the semi-auto ban ruling there. It's now in the Court of Appeals there. We did one in a district court in Hawaii on sensitive places because Hawaii is trying to designate every place as sensitive, so your CCW is no good there. We did one in Illinois on their semi-auto and magazine capacity law. So CRPA is getting onto these friend of the court briefs in other states, taking advantage of the knowledge that we have and the experience we have with litigating against the California laws and the things that have happened as a result of those bad California laws, and bringing that to the court's attention in other states. And at the same time, CRPA, not their lawyers, but the CRPA staff is reaching out to these other state associations who in many cases are bringing these lawsuits in the other states and offering to help them to become more influential, to benefit from the experience that CRPA has had in developing its programs and its training and its lobbying and its fundraising and all the different parts of operating the CRPA that we've learned so much about and gotten so good at in the last 6 or so years. Grassroots chapters is a huge one. CRPA is offering the benefit of our experience to these other state associations to try and help them become more influential. And because there is a push in all these blue and purple states to push as many, whatever they can get away with, whatever they think they can get away with. And so it's important to stop these in the other states, because stopping them there will benefit us in California because it becomes legal precedent, national legal precedent. And any one of these cases could go to the Supreme Court. And obviously once the Supreme Court rules, that applies all across the country. So we have to keep an eye on the national scene and stop whatever bad laws that we can in other states. We do that through amicus briefs. CRPA is typically not the main party, not the plaintiff in these lawsuits. The state association in whatever given state it is. And so, but we can definitely help them by joining on to amicus briefs. And most of this is coordinated by the Second Amendment Law Center, which we've talked about before, which is coordinating amicus brief campaigns all across the country right now. Illinois, Delaware, Hawaii, California, Oregon coming soon. As the decisions come down and the cases go up on appeal, and sometimes even in the district court, we jump on them, bring in as many different parties as we can, amicus parties, and I think that actually the big news maybe here is that in Illinois and in Delaware, and even in our CRPA case, the challenging the roster, like 20 states, 20 state attorney generals have weighed in on behalf of their states, opposing semi-auto bans, opposing magazine capacity limitations, opposing, the microstamp, the roster type requirements. That's huge. Newsom is out there talking about the 28th Amendment and having a constitutional convention. He's already got 24 votes against him. That he can't win, but he can raise money and campaign for president by campaigning behind this 28th Amendment ploy. But the fact is, these states have already gone public with their position that semi-autos should not be banned, that magazine capacity should not be limited, and that you shouldn't have this roster where we require a loaded chamber indicator or magazine disconnect or microstamping before you can buy a handgun.
When we did an entire video just sort of talking about the gravity of those states supporting us in our Boland lawsuit. I'm kind of curious, also with all of these anti-Second Amendment laws being exported out of California consistently like we've seen for so many years, but also CRPA being successful in its lawsuits for a lot of those years also. Take out the content of the actual amicus brief. Does CRPA's name on an amicus brief hold any weight in an Illinois court?
That's a good question. And the answer is sometimes. It kind of depends on whether or not CRPA, the brief itself, whether CRPA is on it or not. CRPA is usually in there with GOC and some other parties. The brief itself has weight. The fact that CRPA, if it was just a CRPA brief, it would have less weight. But with more groups on there, it has more weight. And CRPA can contribute uniquely to these briefs because of the experiences that we've had with these laws in California and have seen how they've gone bad and how there's been all these unintended consequences. So we've lived it, suffered through it, and we can talk about that in the briefs. And that's when the California perspective really, I think, pays off.
And correct me if I'm wrong here, but it seems like the investment really lies in the potential for a lawsuit to go to the Supreme Court, right? When we're talking about protecting Californians' rights to keep and bear arms, you get involved in these things, like you said, because we already have the experience, we already have the expertise, we're living through it. But being involved in these cases that potentially go to the Supreme Court and then get ruled on, if they get ruled on in our favor, that affects Californians favorably. If they don't go in our favor, just the opposite. That affects Californians unfavorably. Is that the basic idea?
Yeah, I mean, look at the Ramiri. I may be pronouncing that wrong. The Second Amendment case about whether or not the federal law banning felons from possessing firearm is unconstitutional because it's overbroad. Because there's a lot of nonviolent felons who are banned that shouldn't be. There was no historical analog for that. Not to say that an individual who's a violent individual shouldn't and couldn't be banned, but to ban a class, whether it's felons or marijuana users or misdemeanors, certain types of misdemeanors, or TROs or restraining orders, those kind of things, that's where it becomes problematic because you're just banning a class. The state points out, well, we can do that. Look, we banned all Indians from possessing firearms. We banned all freed slaves from possessing firearms. Not the best illustrations of how the government should be able to ban classes of people from possessing firearms. But the point is that case is now in the Supreme Court. We're going to have to get involved in that because that case, even though it deals with violent felons, is going to, like the Bruin case did, it's going to further refine and clarify how Second Amendment challenges should be judged by the courts. How do you figure out if a statute is or is not constitutional? We're going to have to be in that case through amicus briefs, urging the court to take a position that makes it clear that, that this is a test. The state governments that want to push gun laws are already trying to twist the Bruin tests around. And we need it clarified again, even though we shouldn't, because it's pretty clear. And I thought it was clear in Heller. We spent 12 years with courts twisting that one. So we got to get the Supreme Court to nail these lower courts down again. And whatever the context of the Second Amendment argument is, CRPA has got to be there making our case known, along with all the other amicus parties. But so any case that goes to the Supreme Court, we have to be involved in because it affects everybody, whether it's a case out of California or not.
Well, definitely a reason to keep an eye on the CRPA website. That's crpa.org. Become a member. Help support these lawsuits. That'll also get you access to the CRPA emails that go out. Another way to keep track of all these things. Chuck, I really appreciate you coming on and letting us know about this stuff. Thank you very much for being with us.
All right, guys. Always a pleasure.
Absolutely. And we will keep an eye on these, so please stay tuned and always like, share, and subscribe to these videos. It really helps with the algorithms. We're trying to educate and inform as much as we can, and as we can reach more people, we can educate and inform that much more. So thanks again, guys, and we'll see you on the next one.